Thank you, Chairman Weber and Ranking Member Matsui for holding this hearing today. And I want to also thank our witnesses for testifying before the subcommittee. As a member of Congress, it's our duty to ensure that our laws strike, as I think you've heard, the right balance between fostering open, unbiased discourse and protecting the vulnerable, especially our children, from the dangers that lurk online. We must scrutinize whether the current Section 230 framework adequately safeguards our children from exploitation and exposure to harmful content while still preserving the robust and free exchange of ideas that's essential to our democracy. Mr. Bergman, you spoke about studies that suggest a strong link between social media use and negative mental health outcomes for adolescents, and I think you mentioned this briefly. How can companies be incentivized to prioritize mental health and well-being in their platform design and content moderation policies?
Well, the main reform there is ensuring that there's some level of liability for negligent and reckless design in the platforms, insufficient parental safety controls as well. And I want to thank you for your co-leadership of Sammy's Law too, and the platforms that are disallowing parents the choice of being able to use safety software to us is a reckless decision. And so putting in some level of liability there is going to change that business calculus and is going to protect millions of children from these harms.
Doesn't that also penalize those companies who have not done that, especially small businesses and entrepreneurial businesses that are just coming into the marketplace?
Yeah, the small businesses that have, well, first of all, on the Sammy's Law piece, we're talking about a negligible amount of effort, as you know. In terms of ensuring that design is not negligent or reckless, that should be the minimum requirement for being able to come into the industry. If you're not sufficiently capitalized and you offer your platform up for children and you don't have the resources to make sure it's safe, that's an issue, and that's what current tort law protects consumers from in all other industries.
And it seems like we may have some laws that do offer protection. Ms. Goldberg, you highlighted a number of cases where social media platforms fail to protect users from exploitation and harassment. Are there examples where tech companies have effectively worked within the bounds of Section 230 to protect consumers, and what proactive steps do you believe tech companies should be legally required to take, identify, and remove content related to sexual exploitation, blackmail, harassment?
The positive stories don't make their way to my office. I hear about the most tragic situations that happen through online platforms, and if somebody's just coming to me because content didn't get moderated correctly, there's nothing to hold a platform accountable. Platforms can moderate however they want to.
I think it'd be beneficial to have both when platforms have done things in a proactive way to highlight those as well too, because it gives us a full spectrum of what we can and cannot do. We have a tendency to overregulate. Ms. Tormorello, you stated in your testimony that startups with limited budgets and small teams invest proportionally more in content moderation because they need their corners of the internet to remain safe, healthy, and relevant if they want to see their user growth grow that they need to survive. How might the potential repeal of Section 230 affect the willingness of entrepreneurs to launch new platforms and services, considering the increased risk of litigation? What specific types of legal challenges and associated costs do you anticipate startups would face?
Thank you for the question. And to note, when I talk about startups, I'm not talking specifically about startups that offer platforms aimed at children. I think the startups in our network that are working with children populations that they know our children are very responsible and are building in lots of guardrails because they know they have to. We're talking about kind of general audience platforms that don't ask for driver's licenses when you sign up because they don't want to have that data on you. That feels creepy to them, and they don't want to have to collect it. So they don't necessarily know the ages of their users. And they are the ones, right, like for every larger platform complaint, we have a startup in our network that's trying to disrupt that space, that's trying to provide a safe online dating experience. We have a startup founded by a victim of sexual assault who's using her experience to make online dating safer. She needs Section 230. Examples like that, they're in my testimony, so I won't go through all of them. But without Section 230, if 230 were to be repealed or sunset, especially at the end of next year, those companies would have to think very differently about hosting user content which means, right, less innovation, less diverse discourse online because there'd be fewer places to go, and less expression from users.
And then just very quickly, repealing Section 230, would that benefit or preferentially treat larger companies that currently do not, or at the behest of government, censor content?
I absolutely think repealing Section 230 would give larger companies a leg up. It would build a regulatory and legal moat around larger companies who know that they can invest hundreds of millions of dollars in content moderation, hire tens of thousands of content moderators, and use kind of their legal defense funds to survive in court, whereas a startup can't do any of those things. And I worry that it would create a very unfair advantage for large companies.
Thank you all very much, and I yield back.